Hi there, this is Jonathan Ginsberg. I'd like to talk to you today about student loans in bankruptcy. And big picture is that student loans very difficult to deal with in bankruptcy because the bankruptcy code itself, section 523A8, says that student loans are not dischargeable, meaning you cannot get rid of them in bankruptcy unless you can show undue hardship. And right now, undue hardship is very difficult to show. Basically, it means that you've got to show that there is some medical reason why you'll never be able to pay these student loans back. But let's kind of go back to the beginning and talk about what we can do and some of the options you've got. And first, let's talk about discharge in bankruptcy. And again, this is where you would show undue hardship. And basically right now with student loans, you have two types of student loans. You have the federally issued or federally guaranteed student loans, that's one type, and you have private student loans, that's a second type. Private student loans are not government guaranteed. They're issued by banks like Discover or Citibank, and they are a particular problem for a variety of reasons. But in any case, if you have student loans and you feel like because of some medical condition you'll never be able to pay the debt back, or perhaps you have a parent loan for a child and now you're retired and have some medical issues, you can pursue a discharge of those student loans under section 523A8. It's very, very difficult. It can get expensive. What we are starting to see is a little more flexibility on the part of bankruptcy judges around the country because they realize that people are being basically put into almost involuntary servitude with student loan debt. I think there's even more flexibility with the private student loans because there's not some of these repayment programs. With the federally guaranteed or issued student loans, there are a number of repayment programs, income-based repayment, public service, forgiveness, things like that, which give you a number of options. With private student loans, you have no such option other than to go into bankruptcy and try to argue for undue hardship. So if you feel like you've got grounds for undue hardship, that would be something certainly to talk about with your attorney. My feeling is you're going to probably need to show something more than that you're not going to be able to earn enough money. You've got to show a medical reason why you would not be able to earn a living and pay the student loan debt. But if you can do that and you're prepared, you have the stomach for litigation, my sense is over the next 2 or 3, 5 years, we're going to start to see a little more flexibility on the part of bankruptcy judges to discharge all or part of student loans because, again, it's sometimes just impossible to deal with them. And if you don't qualify for any of the federal repayment programs, or if you have private loans, there's nothing you can really do with that, then it really doesn't solve the purpose of financial rehabilitation and starting over. So I think we're going to probably see more flexibility in the bankruptcy code, although right now it's definitely an uphill battle. So if you've got student loans and you think that you want to try to get them discharged under the undue hardship provision, be prepared for a pretty big fight. So anyway, that's basically what I have to say about discharge of student loans in bankruptcy. In the next video, I'm going to talk about some of the other options you've got and how you can use bankruptcy, not in a discharge context, but how to use bankruptcy to help generate funds to pay for dealing with student loans. So for right now, this is Jonathan Ginsberg. Any questions about bankruptcy or student loan debt, please let me know. Thanks a lot.